Good afternoon, everyone, and thank you for joining us. And thanks to those who have submitted questions. We'll come to questions at the end. My name is Yusufa Hazara, and I am a solicitor in the International Tax Trust and Estates team at Owen Mitchell. And this afternoon, I'm joined by my colleagues, Srijan Mishra from our residential property team, Sarah Al-Jarani from our family team, and our guest Mohammed Maria from Just Wills in the United Arab Emirates. In today's webinar, we'll delve into the world of finance, divorce, and inheritance within the framework of Sharia. As more individuals seek a deeper understanding of how these critical life events align with Islamic principles, the purpose of this webinar is to explore these topics using a case study. If you want to ask any questions, you can use the buttons at the bottom of the screen, and we'll take questions at the end. We'll also do our best to answer them depending on the time. We'll also be recording the webinar, and we'll send you the link after the event. Just before I get onto the case study, a brief introduction to Sharia for those who are not familiar with the concept. So broadly, Sharia is a body of religious law derived from both the Quran and teachings of our Holy Prophet Muhammad, peace be upon him, which govern how Muslims should lead their daily lives. Many countries which have a high population of Muslims will use Sharia to govern their local and civil laws. But for Muslims in secular states such as England and Wales, this can often create difficulties when engaging in religious matters such as finances, divorce, and wills, and the Sharia rulings can vary significantly from the laws of the land. There are many Muslims and even non-Muslims who might migrate to Islamic countries such as the UAE, where there's more acceptance of the use of Sharia. And in today's webinar, we'll explore this topic in the context of family, finance, and state planning. Just a key point to remember that there are different schools of thought within Islam, and the Sharia principles may vary depending upon the school of Islam followed by the client. So although we're going through a case study today, each case should be considered carefully on its own facts. If we can go to the next slide, please. So this is our case study, and to give you a brief introduction to it, so we've got Khalid, who's age 55. He's a UAE national who married Caroline, who's aged 48, now known as Fatima, who's of the Muslim faith. They married in the UAE and they have a court-certified marriage certificate from the UAE. Fatima has dual nationality. She's Emirati and British. They have a son and a daughter. The son is aged 8 and daughter is 5. Khalid has parents and he also has 5 brothers who all live in the UAE. The parents are in their 90s. The father suffers from dementia. The brothers are much older than Khalid and they're not very fond of Fatima. Fatima, meanwhile, has parents and 2 sisters, and they all live in the UK. In terms of assets, you can see this on the screen. They have a UK property registered in joint names, and for the purposes of the case study, it's held as joint tenants, valued at 2 million, and it's subject to an Islamic mortgage. There's also UAE property in joint names valued at 3 million, and there's no mortgage on this property. There's a joint bank account in both the UAE and the UK. In Khalid's sole name, we also have an investment portfolio in a non-GCC country. Both Khalid and Fatima are resident in the UAE at present time. The children are in international school. Khalid's plan is to keep the family in the UAE, but in the longer term, Fatima would like to move back to the UK. So we'll be looking at 2 scenarios today and addressing some of the questions that are commonly asked by clients and also professionals who might not specialize in this area. So looking at the first topic, we've got the passing away of a spouse. So the first question I have to Mohammed from the UAE is that assuming Khalid is resident and domiciled in the UAE, he passes away and unfortunately hasn't made a will in the UK for his UK assets or in the UAE. Can you tell everyone what happens to his assets in the UAE?
Good afternoon, Yusufa. Thank you very much for having me on this very this talk itself. I know a lot of questions will arise from everyone, so I'll just try and keep it straight to the point. Number one, in the UAE, they operate on tenants in common, not joint tenants. So whatever Khalid has, whether it's single or joint with Fatima, look at that share as 100 shares. So anything joint with Fatima, Fatima will keep 50% of the share. So if they have a joint account, there's 100 dirhams in the account, Fatima will keep 50 dirhams. what the UAE will do is club together all the shares, monies, everything that Khalid has. Now, if you look at the shares as 100 shares, it will be split as follows. So whatever's joint with Fatima, she keeps 50%. That's 1 point. Whatever's in Khalid's name, look at it as 100 shares. She will take 12.5%. Khalid's parents will take 16.66 each, and the balance will go 2 shares to the son, 1 share to the daughter. Now, the control of the shares for the children is usually under the father. So Khalid's father will become a trustee of the shares for the children. Because of his condition, I'm assuming internally, they will get a power of attorney and give it to Khalid's brothers to have the control of the children's shares. Nevertheless, that is the terms of the split of the estate and the control of the children's shares. So for Khalid, being a Muslim and an Emirati, he cannot make a will. If he does make a will, he only can make a will of 1/3, up to 1/3. And even that 1/3 cannot go back to a legal heir. So his mother, father, wife, son, daughter, they're all legal heirs. So you cannot make a will to any of them, because according to Islamic law, a will cannot be given to a legal heir. Now, when you're talking about different schools of thought, I know in some schools of thought, they say the 1/3 can be given to a legal heir. However, in the UAE, you cannot do this. So out of the Khalid's share, club it together, whether it's the car, the bank account, the property, whatever it is, club it together, 12.5% to Khalid's wife, Fatima, 2 shares to the son, 1 share to the daughter, and 1/6 each, technically 1/3 to the parents. And in this case, I'm sure the brothers will be controlling the parents and the children's shares. So Khalid's wife, Fatima, will take the 50% plus 12.5%. Hope that explains.
Okay, that's really helpful. So we assume that most of you on the webinar will be lawyers or from a financial background, but just in terms of the UK assets. So we've deliberately made them to be joint tenants. So the UK property and the UK bank accounts will pass in accordance with the law of survivorship in England. So the survivor, Fatima, will take the assets. In relation to the non-GCC portfolio, it could be that the law of domicile might apply. So again, it's possible that Sharia law might apply to the non-GCC portfolio, depending on Khalid's domicile, which we've assumed is the UAE. So Mohammed, moving on to the next aspect, what I've said about the assets in terms of English law, could Khalid's family try to apply Sharia law to the UK immovable property or any of the UK assets? And would the UK apply Sharia law?
It's a very good question, because Khalid is domiciled in the UAE, and assuming that the family tried to contest the estate in the UK, what happens? From my experience, the joint tenants works, which means Fatima will get the share of the estate. It will pass automatically to her, but it doesn't mean you can't stop someone from contesting the estate. If they do it, the joint tenants will work in the UK. That's why it's important that Khalid has the asset in joint names, and I strongly recommend he makes a will as well to have a second layer of protection.
Yeah, and I think in terms of English law, so say the asset wasn't in joint names, or you sever the tenancy so that he owns 50% and Fatima owns 50%, it's possible to make a Sharia compliant will in the UK. But as you said, Mohammed, he cannot make a will in the UAE apart from the 1/3 of his estate. The rest of it will pass in accordance with Sharia. So you have to work with UAE and English laws to make sure that if the family wants something that's different from Sharia law, that's complied with. Okay, so that was really helpful. Let's change the facts now so that Fatima has passed away instead of Khalid. Mohammed, what would the position be if she had made an English will dealing with her worldwide assets? Would the UAE accept the English will? Or if, in your opinion?
Yeah, sorry.
That's
Yeah.
right. Yeah.
Yeah, Abu Dhabi court is now accepting a will and a grant of probate from the home country of any national. So if you get the will probated, get the grant of probate and submit it to the Abu Dhabi court, I must be very clear about this, the Abu Dhabi court, not the Dubai court. If you submit the paperwork to the Abu Dhabi court, they will accept the grant of probate and the will coming from any country. However, every document has to be attested from the UAE Embassy, the FCO, Foreign Commonwealth Office in, I think they're in Milton Keynes. All the documents have to be translated into Arabic and certified by the Ministry of Foreign Affairs and the Ministry of Justice in the UAE. The courts will accept it.
Okay, so would you say it's preferable from your experience of being in the UAE that she should have made a separate will for her assets in the UAE rather than relying on the English will?
I always recommend a will. I admit for Khalid, he has restrictions. I mean, Khalid may be able to set up a foundation in his lifetime, but that's a different subject altogether, where there will be some control of the estate after his death. However, I know he cannot make a will in the UAE, only up to 1/3. He can make a will in the UK, but for Fatima, she can make a will in the UK and the UAE. So having a will, it's very important. And with respect to everyone on this talk, the dead cannot speak. Nobody knows the wishes of the deceased. So having the will, for me, is a voice from the grave telling someone, hey guys, this is what I want. And for the court is all paperwork pushing, getting the paperwork sent and executed accordingly.
Yeah, so that was all on the succession aspect. And we mustn't forget the tax, because what might be, if Fatima makes a will for her UK assets, we'll need to think about her domicile. So we've deliberately left the case study to be a bit vague on her domicile. Again, everybody should note that there might be a limit to the spouse exemption that might apply if she does leave assets to Khalid in its entirety, that there might be a cap on the English spouse exemption applying up to £325,000. But again, there are options to elect. But keeping tax aside, because that's a separate topic in itself, my next question is to Sarah. What would happen to the children on the death of either Khalid or Fatima?
Thanks, Yusufa. So this is a great question, and it crosses over onto a lot of what Mohammed just said. It's important to know the wishes of somebody whilst they're alive, and that's in regards to your estate, even your children, and care for them. Because as Mohammed said, once you're gone, unfortunately, it's hard to know what you wanted. Looking at this from an English perspective, so in the courts of England and Wales and our jurisdiction, we have what we call parental responsibility. So mothers have it automatically for their children, and fathers get it by being named on the birth certificate or married to the mother at the time of the birth. Parental responsibility is just a way of knowing that you have rights, responsibilities to care for the child and to make certain kind of arrangements for them, whether it's what school they go to, what name they have, whether they go abroad, things like that. Now, when you have two parents here, let's say Khalid and Fatima lived in England, they both have parents' responsibility for their children, and either of them were to pass away, then the parental responsibility remains with the other parent, and they will be looking after the children. They'll be responsible for them. Where this crosses over into wills, and it becomes quite interesting, is you can leave a provision for what we call a testamentary guardian. So Khalid or Fatima could put a provision in their will to say, I appoint, so an individual called Omar, he's a family friend, I appoint Omar to be a testamentary guardian for the children upon my death. On the death of either Fatima or Khalid, as I said, with the other remaining alive and having parental responsibility, they will be responsible for the care of the child. Where we caveat that and the will comes into play is if we have a lives with order. So Khalid and Fatima have fallen out. They've had to go to court over the arrangements for the children, and the court have made an order to say the children live with Fatima. So it's a lives with order, regardless of any other provisions. It's a lives with order. Fatima leaves a will, and she appoints Omar as the testamentary guardian. Upon her death, Omar will become the testamentary guardian, and Khalid will remain to have parental responsibility. And so both of them will be responsible for the care of the child. It becomes a little bit more complicated when you look at Sharia law, because under Sharia, we don't have kind of this idea of parental responsibility. And we'll come on to that a bit later in the webinar.
Thank you for that, Sarah. That's really interesting. Moving on to the finances region. So there is an Islamic mortgage registered against the UK property. What would happen to this mortgage should either Khalid or Fatima pass away?
Thank you, Yusufa. So there's two main options here, but before answering your question, I think it might be helpful for me to give you a very brief overview of how Islamic finance works in the context of UK property ownership. So as many of you will know, the fundamental principle of Islamic finance is that a lender isn't allowed to charge interest on the money it lends. The lender still needs to make a profit on the money it's lent, and fitting this in within the confines of English property and tax law isn't without its difficulties. So one of the most common Islamic home finance products available on the market in the UK is something called diminishing musharaka, which is essentially a partnership or joint venture between the bank and the borrower or customer. How it works is that the bank would purchase the property on behalf of the customer, and the beneficial interest in the property would be split between the bank and the customer in a proportion which represents the LTV, or loan to value ratio, as it's known in a conventional Western interest-bearing mortgage. The borrower will own part of the beneficial interest in the property, and the bank will own the other part. So in respect of the part which the bank still owns, the borrower will do two things. Firstly, they will take a lease of it, pursuant to which they will pay rent to the bank. That rent effectively represents the interest, as it would be called in a conventional mortgage. And they would also pay monthly installments, so payment installments, you could call them acquisition payments, in order to gradually buy back the proportion which is still owned by the bank. And that is effectively the capital repayment. So over the course of time, over the life of the mortgage, gradually the bank would have made its profit, and the customer would have acquired the full 100% beneficial interest in the property, at which time the structure would be redeemed, the mortgage would be redeemed. Now, like I said, the bank would buy the property initially on behalf of the borrower. So what we call the superior title to the property would be registered in the name of the bank, and then the bank would grant a lease to the borrower, pursuant to which the borrower would use and enjoy the property for whatever purpose they're buying it for. So coming back to your question as to what would happen on the death of either Fatima or Khalid, well, depending who's passed away, if the survivor is able to afford the monthly rental payments and acquisition payments, the bank may well say, well, we're happy to let this continue and nothing really needs to be done. The lease of the property, which is registered at Land Registry, would need to be updated to reflect that, well, one of the proprietors has passed away. And on that note, I think it's very important to ensure that the ownership of that lease is structured appropriately, so either as tenants in common or as joint tenants. What you don't want happening is that the deceased leaves their share in that lease to someone else who is not going to be acceptable to the bank. Issues in relation to affordability, suitability for the loan come in, and the bank may not like it. They may not like someone becoming involved in the mortgage structure that they haven't approved beforehand. It may be an executor, and then you need to see what the deceased's will says. So if the bank is happy, then nothing really needs to be done. Just the title needs to be updated to reflect that one person has passed away. If the bank isn't happy, for whatever reason, because the survivor may not be able to afford the loan, their loan may not be suitable for that type of product, because there may be the involvement of some other third party, the bank may insist that it's all paid off, everything is paid off, the mortgage is redeemed at that point in time. And that's when things get a little bit more complicated, because as I said, the bank would have actually bought the property on behalf of the customer. They would have, they will have leased it to the borrower. So that structure needs to be collapsed. So the first stage of that is that the lease needs to be surrendered back to the bank. Sounds like a straightforward task. It should be, but unfortunately it isn't. From the bank's perspective, they're making a chargeable acquisition for stamp duty land tax purposes. So there may be some unforeseen tax consequences there. We don't know. It should be avoidable, but if it isn't structured properly, it may not be. From the borrower's perspective, once that lease has been surrendered, they would have the title, the superior titles, or the freehold, if it's a house, if it's a freehold property, transferred from the bank back to them. So the bank is giving them back the property because the loan has been paid off. Very important to make sure that tax stamp duty doesn't arise again a second time. That would have been paid at the outset of the acquisition. Again, there is, HMRC recognizes this. There is a relief code, code 20, it's called Alternative Property Finance Relief. I believe it's set out in section 71 of the Finance Act 2003. But again, there are very, very strict conditions to that relief being available, and you certainly wouldn't want to pay tax twice. So I think, yeah, in summary, those are the two options. They're much the same as they would be in a conventional Western mortgage, but dealing with it, the practicalities and legalities of dealing with it are a lot more involved.
Thank you, Srijan. So we've had a couple of questions in the Q&A box in relation to the first scenario, which we will hopefully leave some to be answered live, and we'll address some of them in the box as we go along. Moving on to the second scenario. So this is the position where Khalid and Fatima unfortunately divorce. We'll start with the family law aspect. So this one is for you, Sarah. What are the options for both parties in terms of jurisdiction? Can they divorce in either the UAE or the UK?
So this is something that comes up quite often and is a really interesting area of law. Which jurisdiction shall I divorce in? Where shall I do my divorce, and what works better for me? Starting with England and Wales, before we look at whether they can divorce, we need to consider whether their marriage is valid in our jurisdiction. So here we have what we call the Lex Loci celebrations principle that we follow. And essentially what it means is the courts of England and Wales will recognise a marriage that's taken place abroad, providing it meets the customs, practices and requirements necessary for it to be a valid and legal marriage in that country. Here, in our scenario, Khalid and Fatma have had their marriage in the UAE. It seems to be valid because it's court certified. Great. On face value, it seems as though it would be valid here, and therefore our jurisdiction recognises their marriage. Islamic marriages can add an extra layer of complexity to that. And if we have a couple that marry in a Muslim state, so Iraq, Egypt, Pakistan, for example, and they have an Islamic marriage in that country, it's likely to be recognized. Again, we look at it in detail, but likely to be recognized in Islamic marriage to be lawful in that country, and therefore our jurisdiction will recognize it. Where we have an Islamic marriage in England, it's not recognized. If it doesn't comply with the necessary requirements to be a legal marriage, then the Islamic ceremony itself will not create a legal marriage, just as if it was in another non-Muslim state. So France or Germany, for example, Islamic marriage there, if it's not lawful and not recognized, it's not recognized in this jurisdiction. So we take it on face value that Khalid and Fatima have had a legal marriage. It's recognized in the UAE and therefore it's recognized here. Great, we tick off that first box. Can they then divorce here? Well, it depends on whether they meet the requirement. So if they have been domiciled here or they are habitually resident here, the two main categories, then they can look to make a divorce application for a civil divorce in our jurisdiction. the complexities that I get from a lot of my clients who are Muslim and choose to do that is the civil divorce won't necessarily end their Islamic divorce. The two are separate streams, and it means they need to seek the assistance of an Islamic body such as the Sharia Council or their local imam to be able to process the Islamic divorce whilst the civil one is ongoing. So you almost have the two running either concurrently, before or after, but they're separate processes. So to answer the question about England and Wales, they could potentially divorce here. They check the first box in that their marriage is legally recognised, but then we have to look at their habitual residence and domicile in order for them to be able to process that claim. Now, where I find it really interesting is the UAE jurisdiction. Under the UAE jurisdictions, and I'm talking about all of the Emirates other than Abu Dhabi, as Mohammed said, they have a new system, completely different. So we could do a webinar on it ourselves for a couple of hours. But we look at the other Emirates for today. So within those Emirates, generally speaking, Muslims in the UAE, at a starting point, are able to use the laws of the country that they married in to divorce in the UAE. So if Khalid and Fatima had married in England, they can use the laws of England and Wales to process their divorce. The laws will be interpreted into Arabic. They use the civil code to bring into it, and it means they can choose to use the law of that jurisdiction, and that's the starting point. Now, unfortunately for Khalid and Fatima, they are unable to use that, or fortunately, depending on what they want to do, because Fatima is a dual national, so that's one of the restrictions, and Khalid is an Emirati national. So anyone with dual nationality or an Emirati national who is Muslim cannot use those laws. And they fall back onto Article 98 in the UAE, which essentially is a body of laws. It's the personal status law, which is very, very heavily influenced by Sharia law. So a lot of it then falls down onto what we know from Sharia law, what's in the Quran and what's in our Islamic teachings. Where Sharia law applies in divorce proceedings, Khalid is able to divorce his wife. He can divorce Fatima by providing her and announcing that he gives her a talaq. Talaq being the Arabic word to end something, to divorce something. So he provides her with the talaq. They have a 3-month cooling off period, known in Arabic as the idda, during which time, if they choose to reconcile, they can. But if they don't, then after that 3-month period, their divorce is finalized. The UAE, because it recognizes Sharia law, and that's part of the legal system there, for Khalid and Fatima, it means they can do this through the proper channels. They can go to the courts. They'll be required to go through a conciliation process to try and reconcile. And if it's not possible, then the correct paperwork can be drawn up for them. Now, a lot of people say, oh, well, how come the husband can divorce the wife and she can't divorce him? And there's a lot of miscommunication about what happens here. So during the marriage, what can be organized between the parties and the imam, the Islamic leader, is the wife can be given power of talaq. So that's the first thing we check. We look at the nikah, the marriage certificate, and we check, does the wife have power of talaq? If she doesn't, then she can apply for a khulla, which is where the female, the bride in the marriage, will apply for the divorce, but she has to give grounds. So similar to how prior to the no-fault divorce era we had in England, we had behaviours and different grounds. It's the same thing here. The wife has to give one of the grounds or meet one of them in order to apply for the khulla. Examples of the grounds are the husband not providing for her financially, or if he's sentenced to prison for over 3 years, he's gone for a period of time, lots and lots of different grounds. But just because the wife can't give talaq doesn't mean she's stuck. So it's always worth, looking at the various options and seeing what else she can do.
Thank you, Sarah. And what you said about the marriage being recognised in England and Wales, it's really important, the Islamic marriage, because from a state planning perspective, that's also something you have to look at as a tax or state planning lawyer, because it determines whether the parties will get the benefit of spouse exemption or even succession. There could be occasions where the parties are married at home and it's not a validly recognized marriage under English law. So that was really interesting. So moving on to my next question, which is again for you. What does Sharia say about the couple's finances? So the first question, if they were divorcing in England, how would the finances be split in comparison to the UAE? And Mohammed, you might want to chip in on this if you've got anything from a practical perspective, but starting with you, Sarah.
Okay, so we'll start again with England and Wales. Generally speaking, and I'm really generalizing the principles here, but Khalid and Fatima have lived here, they want to divorce here, we're looking at their finances. The starting point is to accumulate all of the assets. Often we call this a marital pot. So we put all the assets together, we look at what's available. And then the starting point is the sharing principle. So we look at how we can share out the assets in an equal manner. But we look at the parties' individual needs as well. So can we deviate away from equality? What are the needs of the individual parties? Let's say Fatima, for example, the children will live with her full time, so her financial needs are greater. Or if she's worked more, her pension and earning capacity is greater than Khalid, so his needs are greater. Lots and lots of different things that we look at, lots of submissions and arguments you can make, but they're the general principles as to how everything is divided. We can also look at inheritance, if that's come in. We can look at pre-marital acquired assets, so what happens with those, post-separation assets. But the general principle is we look at everything, see how we can divide it, and make sure that the parties' needs are met as much as possible. Sharia see things very, very differently. So under Sharia law, we don't have matrimonial assets. It's almost as if the parties are cohabiting in the UK. Whatever you bring to the marriage, that belongs to you. And that's pretty much it. So it makes things slightly easier because there's no arguments over it, in that it can sometimes be clear. I purchased this car, I purchased this house, I leave with it. Joint assets are usually split equally by the parties unless you've got evidence of how much you've put towards it. But again, it's almost as if they are cohabiting in the UK. Throughout the marriage, with regards to finances, the husband has to provide the wife with what is necessary to keep her going day to day. So clothes on her back, a roof over her head. And we call that nafaq in Arabic. So it's just her general kind of spending that she needs to live day to day. Other than that, on divorce, the husband will need to provide for her during that iddah period, so the 3 months. After that, there's generally no maintenance, no other provisions, and it ends there. Where it can be a little bit complicated when we deal with finances in England and Wales for Muslim couples is with mahar. So mahar is often interpreted, or you see it translated into a dowry, but it's not really a dowry. There's just no English word for it. And what a mahar is it's a gift that a husband must give to his wife. It can be given all at the start of the marriage. It can be given at mitqaddam, which means up front, and then mitakhar, so later on. And it's often given in the form of gold, jewelry, money, sometimes other assets such as a house or a car. But a lot of the time we see it as gold and money. And there are set rules in terms of what happens with the mahar, which are set out throughout the Quran about what happens with it. Generally speaking, if the husband requests a divorce, he must provide all of the mahar to his wife if it hasn't been paid yet. If the wife requests a divorce, then she can make arguments for if she needs to keep some of it, but the majority needs to then go back to the husband. Very, very clear and easy in an Islamic state such as the UAE to deal with, because they have those provisions built within their legal frameworks. They know what to do with it. In our jurisdiction, mahar isn't anything, and the nikah contract isn't really recognized legally. And therefore, we have to think of ways in which we can bring those provisions into those financial agreements. So when we sit down to mediate, when we have a roundtable meeting with the parties, if they wish to comply with what's been agreed in terms of their culture and their religion, then it's something for them to try and agree to so that we can build it into the legal provisions here. Mohammed, how do you see it working practically kind of day to day in the UAE?
Look, if I can just say one thing, this is just my humble experience. The expression hanging your dirty linen in public, it came from divorce. And I can tell you one thing, when it comes to divorce, people are changing religions, changing nationalities. They're always looking out for number one, which is themselves, where they can benefit more faster. So whether it's the UAE, whether it's the UK, I've seen cases in the UAE where people using the UAE law because they thought the Sharia will be in their favor, even though they're not a Muslim. And vice versa, I've seen Muslims saying, well, I want the laws of Canada or the UK to be applied because it was in his benefit. So when it comes to divorce, I'm going to touch on what Sarah said on certain points, that first of all, the meher, it's a gift the husband gives to the wife, and it's part of the marriage contract between the husband and wife. So the gift can be given on the day of marriage or any time. Now, if the husband is divorcing the wife, he has to give the meher if he hasn't done so already. So meher could be £500, it could be a gold set, it could be a car, it could be a property. It's between the husband and wife what they decide. If the wife is asking for a khula is where the wife saying, I want a divorce, but the word is khula, not divorce. Then the wife will have to give the meher back to the husband. Now, why would one person want to divorce, or why the wife would ask for a khula? This is something, I'm sorry to say, nobody can give you the answer. This is facts of life. This is why I always strongly recommend make a prenuptial agreement, or in some cases, you can even now make a postnuptial agreement, so you can iron out these differences. Remember in the beginning, I told you a will is a voice from the grave. Well, a prenuptial or postnuptial is a voice from the person while they're alive. And believe it or not, in the UAE, you can have such documents registered in your lifetime. So when it comes to the actual divorce, yes, what Sarah's saying, it is a case where what the husband owns is his, what the wife owns is hers, and what they've accumulated is usually 50-50 given back to one another. But one thing is very important, and everyone needs to understand this, that when it comes to the three major responsibilities of the husband is to give food, clothing, and shelter to the wife at all times, even when he's married, even when he's divorced. Now, when he's divorced, there is a time frame of how much food, clothing, shelter he should give to the wife. So it could be up to 1 year. If there's children, it could be longer, maybe till the children reaches the age of maturity. However, what I'm trying to say is important. Make an agreement, write this all down, because I know when it comes to divorce, everyone is looking out for themselves, and they will twist and bend the laws and the rules together. In the UAE courts, I'm sharing this from experience of my clients who have divorced, that the first thing I do is tell them, make an agreement, don't fight over the matter, talk about the custody of the children, how you want the assets to be divided, make this agreement, write it, share it, write it meaning draft the agreement, sign it, take it to the court will accept it. The problem is when the couples are fighting one another, it goes to the court, wife is saying I want UAE law, or husband saying I want laws of UK, or vice versa, because they know that the law of the other country may be better than the local law, or vice versa. So when it goes to the court, the judge would sit down and decide, and everything is sort of like case by case. But one thing the courts are very strict about is for the wife to get food, clothing, shelter. There's no question about that. Secondly, the children will stay with the mother until they reach the age of puberty. And after that, then the children may have to be interviewed by the court that who do you want to stay with the father or the mother? Furthermore, all the costs for the children's education has to be borne by the father. Now, if the mother wants to remarry after the cooling off period, as Sarah said, the iddat period, then she will lose the custody of the children, it will go back to the father. Why is it like that? Because the children is following the bloodline of the father. And one thing I'd like to share with you all, if you look at any, and please, I'm not being sexist here, I'm just following a certain fact. So if I'm going to offend anyone, I apologize. I humbly apologize in advance. If you look at the family tree of any family, is always the bloodline coming down from the top to the bottom. It doesn't go on the woman, it's always the male bloodline coming down. So the children stays with the father because they will be carrying the name of the father, not the mother. Mother may get remarried, she may remarry tomorrow, adopt another name. So you can't expect the children to keep changing their names if the mother remarries. So if there is a divorce, then the children will stay with the mother until they reach puberty. Afterwards, it's a separate application where the court will decide if the children will go to the father or whatever they decide. All financials will be borne by the father, but if the mother remarry, it's automatic dismissal. But something even more important, majority of the cases where the expats divorce, the wife would usually tend to leave the country and take the children, because they feel like they're more protected in another country. That's why I told you, everyone will change the laws or adapt the laws that would suit them most. So when it comes to these matters, the UAE is not going to get involved, because if the wife moves back to the UK and she remarries and do what she likes, the UAE is nothing to do with them. It's now the children, and the mother is not in the UAE. But there's been cases where the father has actually put a police case to stop the wife and the children traveling out of the country so you can have the upper control. Now, if I was defending the wife, I would say what the husband did was out of order. But if I was representing the husband, I will tell him, block the wife and children, because if they leave the country, there's nothing you can do. It's always case by case, and it really depends who's representing who and what information they're given. Hope that answers the question, Yusufa.
It does. Thank you, Mohammed. And Sarah, just very briefly, because I'm conscious of time, how would the position compare if there's a disagreement between the parents for the children in the UK? So Mohammed's told us about the UAE position, just briefly on the UK point, so we get a nice comparison as to who would, what would happen if there's a disagreement between the parents.
Yeah, so in terms of parental disagreements around children, if the parents can't come to an agreement, they can't use mediation, then they can make an application to court, and the courts look at where the children live and who they spend time with. Generally speaking, they're the two main things that the courts consider, and they could put into a court order. Now, as I said earlier, it's very, very different with Sharia, and Mohammed's touched upon it, because this idea of parental responsibility and custody isn't the same. Under Sharia law, we have custody of children and guardianship, and the custody is seen to be what the mother generally provides in terms of nurture and care and looking after the children until they reach a certain age of puberty, but some jurisdictions will set out what that is. So in the UAE, it's 11 for boys and 13 for girls. At that time, the custodianship generally transfers to the father. Father will always have guardianship, whereby he's responsible for supervising, protecting, educating the children, giving them consent to marry as their wali, which is what we know as a guardian in Arabic. So the two are very, very different positions. And as Mohammed said, you know, if you apply these laws in the UAE under Sharia law, you don't have that automatic, both parents have responsibility. We try and look at their time and how the child can spend time and have a relationship with the parents. It's more about the role of the parent and what they can bring to the children.
Oops. Thanks, Sarah. So I guess it means coordinate the two different rules applying to the children and document and plan ahead and get advice from you in the UK and advice from Mohammed in the UAE to align it together. The last question on this scenario, we've got lots of questions coming in. I'm going to use Rijan, and it's again refinancing of the mortgage. So I'm changing the facts of our case study slightly. What would happen if one of the surviving spouse decides to remarry, and just say they remarry a non-Muslim? What would happen to the financing of the mortgage?
Well, I don't think it would make a huge difference, Yusufa, and the reason is a lot of the Islamic banks I've come across are perfectly happy to offer a Sharia compliant product to a non-Muslim. In one publication, apparently 30% of Al Rayan Bank's customers, well, borrowers of their Islamic products are actually non-Muslim. I've come across several myself. It may often be the case that the lending bank has sort of very different criteria to other banks out there. So a non-Muslim from, say, Lebanon or Jordan that I've come across may find it easier to get a mortgage from an Islamic bank and an Islamic product as opposed to a conventional mortgage on the UK high street. And it's not just the borrowers that are also relevant to this. Islamic banks also seem to have a very different risk appetite in relation to the types of properties they lend. They seem, from my experience, to be able to push mortgage offers and valuations through very, very quickly. So yeah, I don't think it would make a huge difference. Just a couple of things to bear in mind, though, regardless of whether it's a Muslim or a non-Muslim taking out the product. Restrictive covenants in Islamic security documents can be quite onerous compared to what you would see in a conventional Western mortgage. They can have very sort of strongly worded negative pledges in them, which prevent them from dealing with any of their other assets. That's something to look out for. And then obviously there are the sort of covenants which derive from Islamic principles. So, for example, in relation to the consumption of alcohol, so on and so forth. So it's those are things that might be of interest to non-Muslims when they're taking out that product, something that they may want to look at more carefully. Another thing that I didn't touch upon before, I think, was life assurance. Life assurance is obviously very, very important, whether you're Muslim or non-Muslim. But as far as a Muslim borrower goes in the UK, Islamic life assurance isn't actually available here. I believe it is in the UAE, but there is no such product available at the moment in the UK. Mohammed, anything you have to say on that in relation to?
No. Like I told you, in the in the UK, there is no Islamic life assurance. So you'll just have to go for a term policy with no investment element. In the UAE, yes, there is Islamic life assurance. The life assurance offered by the insurance company, the contract is between the bank and the insurance company, and the sum assured is total in the value of the mortgage. So upon death, the insurance company would just make a payment to the bank, and the bank will give the NOC to say that the loan has been redeemed, and then a court order needs to be sent to the land department to transfer the property from the deceased to the beneficiary. So life assurance is mandatory in the UAE. I know it is not in the UK, and it's a shame, to tell you the truth. Life assurance should be mandatory there so that the loans are cleared. But on the Islamic life assurance, from my understanding, there isn't a single provider in the UK. Some of the companies are offering ethical plans, which means it does not contradict what Sharia states, but they don't have a Sharia board to give some sort of ruling over it. So what makes an Islamic insurance Islamically sort of documented? They have a Sharia board where they have senior people who will actually give their signature to say, yes, this is Sharia approved, but there is nothing of the sort in the UK. I know companies in the UAE have tried to open up, try to set up in the UK, but unfortunately the red tape is so much and it's very, very expensive. So just going on the life assurance, yes, for the UK person or people living there, you should have life insurance, but it's not mandatory.
Thank you.
Okay. Thank you, Srijan Mohammed. With my private client hat on again, so on a divorce, Mohammed is restricted under Islamic rules to pass 1/3 of his estate to other beneficiaries apart from the Sharia heirs. But for Fatima, she can definitely make a will in the UK, and as can Khalid. So again, a Sharia compliant will might be advisable if he doesn't want Sharia to apply.
Can I just say one thing, Yusufa?
Yeah, of course.
It's very important you understand that any Muslim can make a will in the UAE for 100% of their money, not the Emirati. So if Khalid had dual nationality, for example, he can register a will for 100% and give it to Fatima. But if he's only got an Emirati passport, he cannot do it. The laws have changed in the last 6 months that Muslims can now make a will of 100%, and it doesn't have to be in line with Sharia. So if, for example, Khalid wants to leave all of his money to his brother, he can do it. Yes, I know Fatima won't be happy, but he can do it.
Yeah,
however,
assuming it's not Emirati.
However, it is only restricted to Emiratis. So any Muslim, whether they are British, Canadian, Australian, Jordanian, Iraqi, owning assets in the UAE, they can make a will. Yes, it's not in line with Sharia, but now the wills are being registered in a civil court, which means they will accept the will.
Okay, thank you, Mohammed. So that answers some of the questions in the Q&A. So we've got 8 minutes for some questions. I'm looking at one which will follow on from what you just said. Will the UAE consider the global assets when determining the Sharia distribution of UAE assets?
Look,
and that's for you, Mohammed.
Look, if I can explain that, let's say you have investments in joint names outside the UAE with the concept of rights of survivorship, i.e. joint tenants, then that will go automatically to the co-owner. But let's take an example. Somebody has a bank account in their single name and they pass away. Now we got to take a step back and think, A, where was the money situated? 1. Number 2, was there will in that country? Number 3, where was the person who died? Where was he domiciled? And number 4, who are the legal heirs? So I always recommend to people, it's important, if you're having a bank account with HSBC in Singapore, that many people do, or you have an account in Jersey, then for God's sake, keep it joint with your partner, so that if you pass away by right of survivorship, the funds will pass automatically to the co-account owner. But I'm sorry to say this, is usually due to trust issues. They keep the account in their single name. So when it comes to death, now you have to deal with the red tape. You need to apply for probate. Now, which country do you apply probate? UK, UAE? So to answer the question, the UAE courts have jurisdiction over the assets in the UAE. But if you're moving money into a different country, then you have to look at the law of that country. As a rule of thumb, I will say, keep the account in joint names. So if it's in a woman's name and she don't trust her husband, for example, then keep it joint with her daughter or her son. Same thing with the husband. Keep it joint with the son or daughter. But it's just, we say, Sod's law, that you want to have all that flexibility during your lifetime, and post-death, you still want the flexibility. But like I told you, when a person is no more, what are we dealing with? What is the religion? Do you know, there are cases people may have converted, changed a religion before they've died. How do we know? Every country has a law. I'm not here to say UK law is better or UAE law is better. Every country's law, plus or minus, it depends on which side of the fence you're sitting on. This is why it's important, I tell people, document everything while you're alive. Sit down and talk about these matters. Unfortunately, talking about death, this is considered in some cultures as a taboo, bad luck. You're inviting trouble. That's why people don't talk about it. And then suddenly when the person passes away, suddenly due to a heart attack, the wife and children don't know where to go. So they're going from pillar to post. This is why I tell people in your lifetime, get the paperwork in order, write everything down, give a roadmap to your family, who they should contact, how they should deal with matters, get the life insurance sorted out. We don't sell life insurance, but go and get the life insurance. Make a list of assets, tell your family where the money is. Nowadays, husband don't even tell the wife which bank account the money is in. Wife is not giving the husband the internet banking credentials. So when you're dealing with a death case, where do you start? Who do you contact? The problems, people make it themselves, and then they expect some sort of something magical to happen post-death, and it doesn't work like that.
Yeah, and Mohammed, a question has just come in about the change in the UAE law allowing non-Emirati Muslims to make wills. Can you tell us when that law came into effect? Was it quite a recent change?
Yes, 5-6 months ago.
Okay, right. So there's a question in relation to family, Sarah. How does the UAE decide on child disputes if the children do not want to go to their father at age 11 or 13? What are the principles used by the court here? In the UK, we have the welfare checklist. Any comments on that? And maybe Mohammed can comment.
I was about to say, Mohammed, if you want to jump in with this as well, but once the children reach that age of discretion, so when the children are at that age of puberty that's determined, if there is a dispute and we do end up in court proceedings under Sharia, the children will still get their wishes and feelings listened to. It's not a blanket, but generally speaking, each circumstance is considered, but their wishes and feelings are listened to. And then everything else falls into place, with the main overarching and overriding principle being the law and Sharia, because the parents will still want to, if they are Muslim and they abide by their religion, make sure they comply with the religion of their and the laws of their God, as well as the laws of the land. So it becomes a bit of a mixed bag whereby, yes, we have the welfare checklist in the UK and we look through that, and the welfare of the children is still considered under Sharia and under different jurisdictions. But the overriding and overarching principle for the parents, if they're religious, is, am I doing what's correct under Sharia law? Hamid, do you agree that's the position?
No, you're 100% correct. Look, when it comes to the custody of the children, like I said, it will go to the mother till they reach the age of puberty. Afterwards, it's like a case that if, for example, maybe the husband and wife are happy that the mother's keeping the custody of the children, she's not remarrying, anything like that. If there's disagreements, it will have to go to court, and the father will put his arguments forward, the mother will put her arguments forward, and up to the court what they decide, what are the next steps. But the children will be interviewed. They will ask the children, what do you want? Where do you want to go? But one thing I would like to say is very important, and this is something that I'm a great believer in. There is joint custody of the children, i.e. it's not a situation where the parent, the mother, can say that the father can't see the children, which I think is very unfair to the children, because there's many people I know personally who have gone through a divorce, and for whatever reason, the mother has got whatever paperwork or whatever the laws sort of decide on, that they can't even see the children, which is, I'm sorry to say, as a man, as a father, it is very wrong that any woman should not allow their children to meet with the father. So one thing good about the UAE, you don't have that problem. It's joint custody, equal custody.
Okay, we have 1 minute and there are a lot of questions, so I think we'll take some of these offline and we'll get back to you on them. Thank you so much for everyone who's joined us today, and thank you to our panelists for sharing your experiences with us. We will send a link out to this event should you wish to listen to this again, or pass it on to other colleagues who might find this helpful. And again, if you have any questions, you've got our details on the webinar slide. So do get in contact with us and we will hopefully be able to help you. But thank you again. And it's goodbye for now.